all of you, and we truly understand and appreciate what you're doing, but just remind you of what the responsibility of the jury is. And I'm going to read from a portion of the jury instruction which you have. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous, but do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. As I said, I know that this is a long process, but I wanted to just remind you of what the responsibility is and encourage you to continue with the deliberations, okay? All right.
All right. Okay, so she just read the responsibility of the jurors to them, reminding that they all have to agree on how it plays out. So the jury in, and now it appears as though the jury is leaving. So this is interesting. Let's listen in now and see. Well, that's it. Come on up. Nick Leonardo just got here. Mic yourself up, Mick, and we'll talk about what just happened in court, because this is quite interesting. All right, what just happened, and if I don't know if you heard it, Nick was just out, and this happened just a moment ago where they were all called into the courtroom. A moment ago, we got word that the judge was allowing our camera crew back in, the pool camera, and called everyone back into the courtroom. The attorneys, okay, the defendants, and you just heard the jury just came in. She came in, sat them down, and then basically said to the jury, we know how hard this is for all of you. And she talked to the jury basically regarding the responsibility of jurors. And she went through it about how there has to be a unanimous agreement. You have to have your opinion in place. You know, you stick to your guns on this, and that's how it is. And she reminded them of that, and then she just dismissed it. And then she said to the attorneys, as the jurors left, I'll let you know if there are any developments. So there is no verdict in either of these cases as far as we know right now. So as I said, had there been a verdict, they would have said, a verdict's in. They would have told the court officer, they would have called us and said a verdict, and we'd all be ready like we have in every other case. In this case, they just came in, and I'm not sure why this would have happened, because calling everyone back in and spending basically, as you just saw, less than 2 or 3 minutes reminding the jury of their duties and then sending them back, that was all she wrote. So Nick Leonardo's here with us, and you know, it's been all day. This is the first we've seen from them. What do you think this was all about?
Well, so I didn't quite get the chance to, you know, I don't know that we were streaming. I was trying to pick it up on a streaming platform.
It was so quick, it just came, and we're probably streaming now. But yeah, as I said, she basically talked to the jury about their responsibilities. The quote, responsibility of jurors, reminding them of what a juror needs to do. And that's it. She didn't ask them any questions. She just told them. So
she may very well have gotten some sort of information that maybe they're deadlocked or they're hung as to one defendant or both defendants. And sometimes the judge can do what's termed what's called kind of a dynamite charge, and that is one where the judge would, you know, read the jury portions of the jury charge that the jury already has, and then they may add to it with this little dynamite charge that may be like a page and a half that basically talks about how, you know, you need to stick to your guns, but you also need to continue to talk about the evidence in the case and talk back and forth, and, you know, kind of trying to suggest to them that they need to keep working. And so I don't know if she told the jurors, I don't know if she told the lawyers before she called them in what she had heard, and I don't know if you picked up on that, if we were just late picking that up.
We heard everything that happened in the courtroom. I don't know if she's met with the attorneys outside of our camera crew being in there. It's possible they did. I'm going to check with our crew out there, but they've told us every time someone goes in, and they haven't seen anyone make their way in there. So, yeah, we heard everything that just happened. It was literally, come on in. She said something along the lines of, I know it's been a long day, it's a hard job, we all appreciate it. And then she told them what their responsibilities are. I mean, they literally in there talking to her for 2 minutes and then gone.
No, so, I mean, she must have told the lawyers, I mean, when you call the lawyers to get them to come back, you let them know. So maybe they knew that maybe there was a question, or that there had been reporting to the judge that they're hung on maybe one or both defendants. I mean, clearly I think we know that Mr. Cowan, I mean, we know that Mr. Hill shot her. They admitted to that. Okay, he admitted to that. So it's the involvement of Mr. Cowan, and whether or not they can arrive at a verdict. You know, I had thought maybe potentially that they had a verdict as it pertains to one of the defendants. And if they had a verdict as to one of the defendants, I think that you could go ahead and take that verdict.
Is it possible they have a verdict on one of them? We don't know that. Is it possible they do yet, but she's going to wait and see if they can get it on both? And if not, at some point by the end of the day, could she just accept that one verdict, clear that off the table, and send the others back to work on the second defendant?
That's exactly what they would do. Sometimes you have an indictment with multiple counts. So you may have, you know, a murder charge, you've got tampering with evidence, and you may have, you know, some other, you know, lesser charges. And say, a lot of times you may have unanimous verdicts on certain counts, okay? And maybe not the main count, and the judge could take the verdict on those other counts and then send them back on the remaining. So if they did have a verdict as to Mr. Hill, she could take that verdict and then dismiss the jury, pronounce that sentence if it was first degree. She could go ahead and impose the life sentence outside the presence of the jury, send Mr. Hill into, you know, custody, and then bring the jury back in and do that dynamite charge, or you know, have that discussion about, as it pertains to Mr. Cowan, you know, take that off the table. Don't give him too much to think about. If they've got a verdict on one, accept that verdict. They got a verdict on other counts, and I don't think there are multiple counts in this indictment. But go ahead and accept it. Take that off the table. You know, their plate's full. Let's go ahead and start taking stuff off their plate if they've arrived at a verdict, because maybe that would help, you know, bring them together.
I mean, they may not have reached a verdict in either. I think if you're guessing they've reached a verdict on one, it's likely Hill. And keep in mind, Hill, we know, conceded that he shot and killed Caitlyn Kaufman. The debate there is whether or not it was first-degree murder. If a juror decides that Hill did not commit first-degree murder, what at the very least would they, based on his confession, find him guilty of?
Well, they could find him guilty of second-degree murder, which is the knowing killing of another, which is a huge victory when you're facing life like that. And they could go all the way down to maybe it was a reckless homicide.
Even if he admits it.
Yeah, I mean, he admits it. I mean, you know, he could admit that it was, that he did it, but they might find the conduct was reckless even. Who knows? You know?
Okay. So we don't know. It potentially could be both of them. It could just be one. I think we're all in agreement that that Cowan being charged with first-degree murder, it opens up the possibility, since he's not the one that pulled the trigger and was driving, that maybe it would be a lesser included offense for him. But we just don't know, and it's been this long. What do you suspect? Is it more likely that they maybe have gone? Would the jury have started, obviously, all right, let's start with one defendant first. Let's make our way through that and then get to the second defendant. Do they kind of start them simultaneously? Let's vote one and then let's vote the second and make our way through. How would they do that?
I mean, I think probably the first thing after they elect the foreperson is they say, okay, how many, you know, do you think both of these guys are guilty of something, right? I mean, you go ahead and get the not guilty out of the picture, right? You know, and so then let's figure out what they're guilty of, and then what ends up happening is that they start going through that jury charge, and they're trying to get some sort of a concession verdict. You know, I think he's guilty of something, but I don't think he's guilty of second, or I don't think it's premeditated murder, but he has a role, he's guilty of something. Well, is it reckless? Is it criminally negligent homicide? You know, you start going down, taking votes, because that's what the charge would say. Start with the indicted offense and then move your way down, okay? And you go in order. I think a lot of times they go down looking through those lesser included offenses and attempt to come up with a unanimous verdict so they can go home, you know, to try to find, you know, what crime fits the set of facts and will give everyone a unanimous verdict.
It's interesting. Can you hand me over the list of lesser offenses that you put together? I mean, let me take a look. Just in terms of first degree, I'm wondering if they say, there may be someone in the room maybe saying, for one of the two defendants, I believe it first degree. And then say one of the others is saying, no, I think based on what I've heard, it's reckless homicide. That's pretty far apart, and they're sticking to their guns. Could they then, as they discuss it, come back and compromise somewhere in the middle? Is that what
I
they'll
mean,
do?
sure. I mean, that's what they're trying to do. They're trying to find a place where everyone agrees.
Where everyone agrees.
I mean, everyone wants to go home, but they also, obviously taking their job seriously, but they're trying to figure out, okay, where do we all agree? Because that's what's going to, send them home.
And keep in mind, this could be 11 in agreement on one of these charges and just one saying, I don't see it. And they have to find a way to work it out. And have you seen times where, as opposed to reaching an agreement, I mean, just one person saying, I'm dead set on this charge, I'm dead set, and they refuse to budge? Is that when you get a hung jury?
Yeah, I mean, that's when
You
they
just flat out refuse to budge, and you're not going to compromise. You can't see any other charge convincing you.
Well, but the judge also, is not going to, after how many days has this been? 8-day trial, maybe? 5 days of proof. They had 5 hours yesterday, and today it looks like maybe they would be going almost 5 hours today.
Yeah, that's right. About 10 hours
so,
approaching that.
I think maybe there may be some discussion towards the end of the day by the judge, calling them back out and asking if, do they have any verdicts on either one, and does, would further deliberations be fruitful? But I don't see Judge Dalton, declaring a mistrial this soon in. And I don't think any judge necessarily would. But you want to keep these jurors working. You want to keep them working, because a lot of times they'll say, "Well, we just can't agree. We're hung." Well, not quite. Y'all need to keep going, and that's what this little dynamite charge is about, is to to persuade them to keep going and say, listen, even though you're supposed to stick to your guns here, okay, you're supposed to stick, but you're also supposed to talk about the evidence, okay, and so you need to listen to other people's perspectives and their comments on the evidence to see if it could. If I had a moment here, I could try to find the additional language that may have been read, but
then you have to be open-minded, because you think after 10 hours maybe that they've listened to everyone else. I mean, you would think by now, if you and I were in disagreement, we would have shared our opinions and tried to explore it, and hopefully it's not adversarial, and you still can't come to an agreement. That's where you start wondering, is it possible that no one will change their mind?
Well, I mean, it's always a possibility, that people get dug in like that. But again, I think it's a little too early. I think there may be some discussion at the end of the day. And again, if they have a verdict as to one of these defendants, then they should go ahead and accept that verdict and then remove them from the courtroom. And if it is first-degree murder for Hill, then go ahead and impose that life sentence outside the presence of the jury, send him on his way, bring him back in, and tell them to work on what's remaining.
Yeah. And again, you're thinking of why this was just held here in open court and bringing everyone in just for that brief moment was so that we could see her reminding the jury that they have to, because really other than that, I'm like, wow, they called everyone in. Couldn't she have just told the court officer to go back there and remind them of it? Why they had to come do that in open court?
It doesn't work like that. So we're creating a record, okay?
Okay.
And the record is what's that, the court reporter sitting in there, and so everything that is said in that courtroom is taken down, and if there is a conviction, at some point they will compile a transcript, and then the higher court, the appellate court, the Supreme Court, they will use those transcripts of what happened at the trial court to determine if the court made the right decisions on the rulings and evidence and whether evidence was sufficient. And so you wouldn't want to just send your court officer back. Now, there could be an example. Let's say that the jury comes out and tells the court officer, we need to know a better definition of reckless, okay? And then the court officer reports to the judge, and the judge could say, just refer them back to the charge, okay? Because it's in there, and it's not the judge's. The charge is done. It's not the judge's job to continue to read into it and to provide guidance. That's not the role of the judge. The judge, they have the instructions. They have a question about evidence, let's say. They may want to rewatch a video, or they may want to come back and review certain, and the judge can certainly do that, okay? But maybe they just want more information, and the judge says, I'll refer you to the charge, and maybe the judge got word that they were hung and maybe told the lawyers to come back, and maybe that was not on the record. But clearly, I think that Judge Dalton and any good trial judge would put whatever's going on behind the scenes would be part of the record.
Okay. So in this case then, she brings them all back in. She says this piece. I'm taking that this was not just, it's been this much time, I haven't heard anything, let's do this.
That's correct.
Something is going on back there, besides just the fact that they haven't reached an agreement. Something is going on. She brought them back out there for a reason.
I agree.
And we don't know what that is, but there's clearly something going on back there.
That's right.
Have you heard in times in the past where juries, because of disagreements, it actually gets personal or ugly?
That I've heard times. I was used to previously be a court officer, and I would be, sworn in with a jury, and I'd be on the other side of the door, and you can't really hear anything, but then you would hear some voices raised sometimes. And I remember maybe a couple of times I thought, well, I might have to go in here, open the door, and say, okay, stop deliberating. Is everybody okay?
Right. But other than that, I just don't. And what I mean is, if they're emotionally invested and they have strong opinions on someone else's life and their future, their well-being, how it's going to play out, and they disagree, and they've been in there for hours, and they just can't see the other person's point of view. And well, I've heard of cases where there've been fisticuffs.
Well, and one thing that Judge Dalton has said, and I haven't had a trial in her courtroom, and I haven't, and this is the first trial, so this is the first time I've seen Judge Dalton conduct a jury trial.
Right.
And she's said several times about you guys don't need to kind of break off in little groups. She's made that comment, right, that y'all need to, if you're in little groups, you can't talk about the case. So it kind of suggests to me that maybe there's been some breaking off into groups and some conversations about the case that have gotten back to her, and she's making it clear, look, you can't, all 12 of you have to be together. The smokers can't go outside and smoke and talk about it. Deliberations only happen when all 12 of you are talking about the case and the door is shut. So she's gone to great lengths
to make that
impression.
Naturally the groups that maybe agree with each other will kind of pair off, if that's the case. But when you're in that room, they all have to be together, and look, they need to find a way to get along because they're going to have to work this out one way or the other. And I'm with you. I mean, how big a deal? Calling a hung jury, and it's been a long time. I can't remember the last one I've been involved with. That is a big, big deal. I mean, not just, we're starting from scratch all over again. The expense to the taxpayer is not the least of it, as well as everything else. Because they can't reach an agreement, you throw everything out and we're starting from square one. All over again. That is a big, big deal. And it shouldn't just be, oh, we can't agree, sorry, okay, let's do that. No. If I'm that judge, they're sticking here the rest of the week. And maybe by Friday, if they can't work it out, then I'll call it. I
think it's a good rule of thumb. You don't need to have them, forcing them to deliberate while they're telling you that you're hung all the way to the same length of the trial. I mean, I do think that she's, I don't want to hate to read into it. I'm sure I'll be wrong no matter what I say, but I would think Judge Dalton would maybe make them come back tomorrow before she declares a hung jury.
Yeah, I mean, it's just, to me, it's got to be that you've explored every avenue. And I know sometimes if you stick to your guns, I respect that, but I have to be dead sure of that and make sure that it's not gone to that point. I've not seen that. Usually at some point in the game, they finally compromise. There's a compromise verdict, which, hopefully you can all agree on.
Well, I mean, and they have to hopefully agree on. They have to agree. That's the thing. It's got to be unanimous.
But meaning that's not. Well, what I mean by compromise is you might think it was second-degree murder or reckless homicide for sure, and you're dead set on that. But I want to go home, so I'm going to agree to facilitation of first-degree murder.
Well, one thing's for certain, two things are for sure is that when they come back with any kind of verdict, the judge, one of the lawyers will, can we poll the jury? Yeah. And I've actually seen when they poll, and the court will ask each individual juror, is this your individual verdict in this case? Juror number one, is this your individual? They'll have to verbally say in open court yes or no. And a couple of times we've seen jurors say no,
really?
Or they shake their head, and then you get a real mess.
Yeah, you better be sure before you go in there. All right, well, you know what we're going to do? I mean, who knows? They could be back at some point after that talking to from the judge, reminding them of their duty.
Well, I mean, there was no great insight put into that. I mean, I don't know that that's going to fix it, but that's the job of the judge to do what she's doing.
Well, that's why I think there's other stuff going on behind the scenes, but who knows? The number is 737-7587. We're streaming live on Facebook and on YouTube, and we're here on the Plus, and Nick's got his legal book, so he's going to dig through that. We'll take a few phone calls while you check that out, and we'll go to Jim. Jim, good afternoon. Hi, Jim.
Hi, Nick. I was wondering about the composition of the jury. I understood it was 9 women and 3 men, and then I found it interesting that the 2 alternates that had been released were also women. And what else do we know about the racial makeup, the age of the jurors, the demographics on the jury?
I don't know the ethnicity of the jurors that were released as alternates. Our understanding, there were originally 11 women and 3 men. Remember, there were 14 chosen. 2 women were excused, and the breakdown was 4 black women, 3 white men, 7 white women. That's how it broke down. I do not know which 2 jurors were excused in terms of whether it was white or black. But the majority of this jury is female, and my understanding is they skew older, 50 and above, though there may be a few that are younger than that. So that's kind of the breakdown on that, and I don't know how much you can read into a demographic of a jury and what this means. It's a hard case, and people bring their own thoughts and opinions to it. Let's go next to Calvin. Calvin, good afternoon. Hi, Calvin. Hi, Calvin.
Hey, how you doing?
Good. What's on your mind?
First, before I want to thank you for taking my call. So I know when this first started, it was like more of you and the other guy. I feel like y'all were a bit rude, laughing and saying, "Oh, hey, he needs to get time and he needs this and all that." Okay, well, I say this to say I don't recall any of this energy when the white officer shot and killed Mr. Daniel Hendrick, or the young guy that was running away and was shot.
Oh, listen, we were going to do that gavel-to-gavel trial with Daniel Hambrick. We were going to do that, and Officer Delkey was charged, and we were prepared to do that, and we would have provided commentary in the very same way we're doing here. But as you know, that just days before it was set to go to trial, and we were going to do it gavel to gavel. It did not go to trial, much to the anger and disappointment of the Hambrick family. To this day, I know they're upset about that. That was the decision made by the district attorney. So, no, this, for me, I don't know what you're implying there, but it's not a black-white issue for me. I call it as I see it, and I can tell you that we would have had the coverage, and it would have been the same type of thing we're doing, and we were set to do that trial. And they reached a plea deal is how that played out. Now, I'll say this, as we go into it, we know that Hill has confessed. You can make the case, and I've said that I think based on some of the testimony, I can see how the jury might think first-degree murder. But you know what? Look, I mean, he talked about how he was under the influence. He talked about, if you believe him, that he shot in a moment of rage and did not premeditate it, and that's very possible that resonated the jury. And that can be why at least a few of the jurors may think that it's not first-degree murder. It's a lesser charge. That's possible. Same thing, okay, with Cowan. He was not the shooter. We heard his attorney do a very good job, I think, of saying, look, he didn't shoot. We heard Hill himself say that Cowan had nothing to do with this. He just happened to be in the car driving that day. And if you don't believe that he sped up to try to get him in position to shoot, then you could arguably make the choice that he's not guilty. I mean, and maybe there's a juror in there with that line of thinking.
It could be.
I mean, you just don't know how jurors think, but that's how it plays out. Call it as as the evidence comes down. But there's definitely some disagreement going on back there, folks. Definitely. What do you got there?
So this is actually in the, this comes from the book of the Tennessee Pattern Jury Instructions, and so this is what all the state trial court judges use to come up with a jury charge. And if it was a bench trial, it would be the same directions to the judge themselves. Of course, the judge wouldn't read the charge to themselves,
right.
Of course. But the relevant portion, so they were already given this charge, and so maybe, and like I said, I didn't hear this, but the judge could have called them back into the courtroom and reread something like this, but it says that it is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purposes of returning a verdict.
Wow.
So that's
a tough one to balance. Yeah, that's it right there.
And that may be what she read. Does that sound familiar?
Along those lines.
Yeah.
I wasn't, yeah.
And this is an old book, but again, they change them a little bit. But that's basically it. You know, is that you need to re-examine the evidence and talk about this with your fellow jurors, and and don't reach an agreement without violence to your individual judgment.
And that's the trick. I mean, you may, if you feel strongly about something, if you compromise, it's going to go against your judgment. And then you decide. See, I guess it's a balancing act. Being a juror can be a tough gig, especially in a case like this. It's a lot of questions, a lot of details to look at. Let's go to Ray up next. Ray, good afternoon, Ray. Hi, Ray.
Good afternoon.
What's on your mind?
Nick, y'all, both of you Nicks are doing a great job, but I'm a little concerned. I thought they'd have a verdict by now because I think they're both guilty of first-degree murder. But I'm just wondering if the jurors is having a problem saying, look, these guys are in a gang, and they done seen us and they know us. If maybe they think, well, if they don't get a life sentence and they get out, they could come back on us and cause some problems. I'm just wondering if that's going on in the jury's mind.
That's a great
Okay.
question. I had an elderly individual had texted me earlier today and suggested that could be part of the holdup too, is that since they know there's a gang affiliation and they're sitting there staring at these individuals and there's people in the galley, that maybe they're concerned that if they do return a verdict that there could have, some sort of gang retaliation or something. So I mean, he raises a good point. He's not the first person to say that, because someone else reached out to me today about that.
Okay, and what do you think, though? As far as we know, there have been no threats or anything along those lines, and the prosecution didn't hammer super hard on the gang thing. They brought that up and were aware of it, but that was about it. But I guess everyone can have their perceptions.
Well, I mean,
of how things play out.
that's a legitimate thought process, and it doesn't mean that it's happening, but I mean that could be a consideration.
Okay, all right. Let's go next to Larry. Larry, good afternoon. Hi, Larry. Hi, Larry.
Hello.
Hey, what's on your mind?
Good afternoon, fellas. Y'all doing a great job.
Okay.
I just wanted to make a statement. I've been a juror on a murder trial as well, and it's not an easy thing to do. You're kind of holding another human's life in your hands.
Yeah.
So I know a lot of times in the case I was in, one or two people would be a devil's advocate, in other words, to try to bring up things to where it wouldn't be a 100% murder. I mean, a lot of people they have, well, yes, they're guilty of first degree murder, but then you have to have people that are devil's advocates to try to sway the jury in all the way to make sure that you're all making the right decision. It's not an easy thing for a juror to put somebody else's life in their hands and make that commitment. That's all I want to say.
Thank
Have
you.
a good day.
Thank you. Sure. Serious thing.
Well,
I mean,
it's
for Hill and
it's
Cowan
not
are humans.
like having your
Right.
life, someone's life. You do have someone's
You
life
do.
in your hand.
And they're taking it very seriously for these
Yes.
two defendants who are innocent until proven guilty in this court of law. By the way, several people who were watching just as it came up, and maybe it was as I was moving, they said what you did read is what the judge delivered to the
Okay.
jury, more or less in that. And it's as you said, and we'll revisit that and remind folks what it was and put yourself in their shoes, how you try to balance, your strong beliefs on something with trying to listen and understand the other's point of view in the room.
Which
and how
clearly
that-
says that they've reported to the court somewhere along the way that they're hung as to one or both. Okay, clearly that's been
Okay.
communicated to the court, because if that is indeed what was read, that was one of those dynamite charges about deadlock deliberations.
Okay, so that gives us a hint as to really what's going on behind there. And we'll see how much longer they go today. Are you guessing by now? Certainly they probably had lunch, and when they did have that lunch, that would have been not while they're deliberating. The judge says she doesn't want that
Correct.
done,
That
right?
door opens and the court officers are in and out, so yes.
Okay, let's go next to Nancy. Nancy, what's on your mind, Nancy?
Hello.
Hi.
I've been on petit jury, grand jury, and federal jury, all within a year. And I can tell you that as it goes on, it'll get more heated because some people just have their views and they'll stick with it. But this is where the foreman comes in, and he can remind them, or she can remind them, we've got to get this done. We've said we would do it. And as far as it being somebody's life, yeah, but you knew that when you said you would be a juror, when at the very beginning. So it does get heated, it does get rough, but you're there to do a job, and you just rehash everything, go through all the evidence again, and hopefully they'll be able to come up with something.
Yeah.
It's just, I'm for the back in the day when somebody would commit a crime like this, and they would admit to it, and you would, and I hate to say this, hang them up, but they will, one way or the other, they'll come up with something.
Yeah. Well, they're going to have to. And she said behind there, it's tough. She's been on a bunch of juries, and it can get heated. But they're doing their duty, and so I give the jury credit. This is hard. Look, they didn't just say, we don't care, let's just vote on something and get out of here. And both of these men, okay, on trial for a horrible crime, deserve a fair trial. That's what it comes down to. They deserve a fair trial. The judge is trying to maintain this. Both of them get their say, and the jury has to take their time with it.
Well, in all fairness, I mean, it wasn't that strong a case against Cowan, and I've said that, and it's a strong case if you start reading between the lines and inferring proof, okay,
right.
Then it becomes a little stronger. But if you just stick with what we've heard, it's not that strong of a case. That's why Jan Norman in closing kept going, they. And I do think that Mr. Cowan's involvement, based on the evidence, is different from that of Mr. Hill.
Sure. I mean, one pulled the trigger, right?
But clearly the facilitation charge, when you read that charge, it talks about, assisting. So he may not have had the same mental intent as is Hill, but by driving that vehicle, he certainly assisted. I'm looking at the charges that you put together. Let's just say they do come back with a lesser charge for, say, Cowan. Second-degree murder or facilitation of first-degree murder. That would be a Class B felony. That would be second one down the line. 8 to 30 years, but with his prior criminal convictions, what would that make him as a range offender? And it just depends on how many he has. I mean, it's.
But we talked about a bunch of them.
Well, we don't know that it's true, but if he's got 3 or 4, he could be a persistent offender.
And if that's the case,
then
how
he
does
would
the
serve.
judge take
he
that
would
into
serve.
account?
Well, so then obviously he would have to serve longer before he would be eligible for any kind of parole.
Okay.
But the prior convictions would allow the judge to increase the sentence.
And the sentence can be on that one, I guess, 8 to 30 years. That's the range. 8 years on the low end, 30 years on the high end.
Right. But so, I mean, anything lesser, without getting into the sentence, anything that comes back as, a facilitation or anything less than
even
first
second-degree murder.
Even second-degree murder would still be a crime that they have to serve 100% of the sentence, okay?
15 to 60 years.
Right. And so, but anything less than that, you start looking at a whole lot less time.
Yeah, a big victory for both of these men.
Right. Well, and I would say that second-degree murder would be a big victory for both these men. When you're looking at a life sentence versus, looking at, getting out of jail and not dying in jail, that's a huge victory.
Gotcha. All right, let's go next to, I believe, Brian. Hi, Brian.
Yeah, how y'all doing today?
Good. What's on your mind?
I was wondering, say I got a crazy neighbor and they come down and they want to ride to the bank and I give them a ride to the bank. They go in, they rob the bank, and they come out and get in the car and I drive them, I come back home. Do they charge me with robbing the bank? I mean, why? I mean, what would be the difference? I mean, it would be just, I don't see any difference. Him driving the car, he's just as guilty as the other one. And I don't know. That's all I've got. I just think that if you take somebody and you rob a bank, then you're just as guilty as the one that robbed the bank.
What do you think? We've talked about that analogy in the past, and it could be a little bit different. Now, if you're in the car knowing that individual's going in to rob the bank and you're preparing to speed away.
That's different.
That's the difference, because Cowan and Hill testified that Cowan didn't tell him and didn't know what he was necessarily going to do. Hill said Cowan had nothing to do with it. So Cowan, you could say, unlike the bank getaway driver, didn't know that Hill was going to shoot her.
That's exactly right. So I mean, and so obviously, if that's the case, you have to believe Hill, because really the only thing that places, if I'm not mistaken, the only thing that really places Cowan driving that vehicle, because the truth is it wasn't even registered to him. We still don't know who this fictitious name is that rented the car from Hertz, but the only person that places him actually driving that vehicle is Mr. Hill's testimony, quite honestly.
More or less, yeah.
More or less. And so, if obviously the jury's believing Hill to some degree, giving his testimony some credibility.
Believing him in what regard? That
he was driving, that Cowan was driving.
That Cowan was driving, correct.
Because, I mean, where else did we hear Cowan was driving?
I'm wondering if there was some reference to it in those lousy quality phone calls we heard and all of that.
Right. Well, we didn't
never
hear
got
that.
to see the transcript, and we didn't.
Right.
And I'm not saying there is, but you all know you couldn't hear a darn thing on that. And I heard you couldn't hear a darn thing much in the courtroom either, which is why the jurors got transcripts. But yeah, you're right. I mean, I think people believe. I think some of what Hill testified to, no doubt, was the truth. Okay, I believe some of it was the truth. Other parts about what they talked about, what they said, whether or not Cowan said anything the moments after he hit the brake, I'm not so sure.
Well, and the jury is, and that's part of the instructions that the judge gave the jury. The jury is free to accept all or part or all, a part, or none of any witness's testimony. So
they may decide some of it's
they
credible.
could decide some of Mr. Hill's testimony was credible.
Okay, let's go next to Colleen. Hi, Colleen.
Hi, Nick.
Hey.
How y'all doing?
Good.
right.
What's on your mind?
I got a question because I'm stunned. I've been watching this trial the whole time, and I noticed Hill leaned over to his lawyer and was telling him something about the juror. I don't know if y'all could see him, but I could. I'm wondering, do the defendant know anybody over there on that juror thing?
Do they know someone?
Yeah, because something didn't look right with me, and I'm sitting here looking.
Okay. Let's not talk about the voir dire process, which is jury selection, which took 2 days at the beginning of this trial. And there were, 3 folks with, you had 2 defense attorneys in the prosecution with all those challenges. Isn't that one of the questions you ask when you're talking? Are you familiar with any of these? Are you related to one of the suspects? Is that how
Yeah, clearly the judge will read off, because we didn't cover voir dire, but typically the judge would read off the names of the witnesses on the indictment. In a murder case, it's going to be a ton. It doesn't mean they're going to call all of them, but the judge would say, do you know any of these people? And some, when you've got 30 or 40 police officers, inevitably somebody, not the people that are impaneled, but somebody out of those 50 people sitting in the galley waiting to be called may raise their hand and say, I know Officer Barris, my kids used to go to school with his kids. And the judge would say, well, it's not automatically disqualifying, but the judge would say something to the effect of, well, does that mean that you would more or less likely to take their testimony as credible if they were called, or does that interfere with your abilities to be neutral and impartial with their testimony if they were to testify? Again, and that's okay to know some of these folks. It's just that you want to make sure that you could still be, neutral and impartial.
But you certainly wouldn't have a family member or a close friend of one of the defendants on the jury.
That's clearly not the case.
I'm not saying that's the case here. Obviously, that was asked and didn't happen.
But more interestingly, though, what about the Bible thing this morning? That was something that I'd never seen, being around this for 25 years.
Remind folks what happened. First thing, really the only thing that the judge talked about this morning.
So yesterday we had noticed, I think it was yesterday, days kind of get caught up when you hear on Saturdays and everything, but so we noticed that Mr. Cowan, what held up to his face, what appeared to be a Bible, and maybe he just was resting his chin on it, kind of like, something to this effect right here. And and we noticed that, and I think we broadcast that. I think some of the callers noticed that, and so today, before the jury came back in, General Moore stood up to the judge and said, "Judge, would you say something to Mr. Cowan about his quote-unquote prop," which was kind of a pejorative term for the fact that he has a Bible, and the judge said, ask him to place the Bible on the table there.
There's the image you're talking about, and at first some people thought that was yesterday, might have been a cell phone or something, but I guess it's a small Bible.
No, right, and so and it doesn't say Bible or anything like that on there, but he clearly he doesn't need to be having Bible verses out there or anything like that. That's completely inappropriate. However, that's a bit of a unique thing, but and of course I think the judge made the right call. He doesn't need to be sitting there flashing religion and Bible verses and the like. It's okay to have the Bible there, but I don't think he needs to be holding it up to his forehead or anything of that nature. So I think
she said leave it on the desk, but didn't say you couldn't have it.
No, that's exactly right. Now, but which is interesting enough, they sure didn't. The state didn't object to Mr. Hill wearing the Kofi. Now, did they?
The white hat
because they think that's going to play to their favor.
Which we
in
think
the South.
That style of hat is related to the Muslim faith, perhaps.
Right. That's why they didn't complain about that. Now, did they?
No, they didn't. And both of those could have
Makes you wonder why, doesn't it?
Can't have it one way or the other, right? I think it's right that both of them are allowed to have those in the courtroom.
No, I think so too. But it's just picking and choosing what works for you, and it's just good lawyering and gaming the system. Quite frankly, that's what lawyers do. That's what they're paid to do.
Yep. All right, let's go next to Bobby. Bobby, are you there, Bobby?
Yes, sir.
Go ahead, sir.
Quick question.
Yeah.
Quick question. If this does end in a mistrial, can they both be retried, or would that be double jeopardy?
No, that's a good question, and yes, they can be retried. And I've seen hung jurors before where the DA says, "Well, okay, judge, pull out your trial calendar. Let's just go ahead and pick another date." And they start looking through, and they'll just reset the case for trial.
You think they do them together again if there were hung juries in both of them?
I think they need to. They don't have much on Mr. Cowan.
Oh, yeah,
right? I
that's
mean,
what
they
it is.
really
Yeah.
don't have anything on Cowan, so I think they almost have to try him again.
Would you not be able to call Hill as a hostile witness?
Well, again,
if you tried.
But hold on.
Okay.
Again, you have the right to remain silent. You cannot be compelled to testify against yourself. So no one can call them as a witness except themselves.
Okay, because what if Cowan was tried second and Hill was convicted first? Could they call him as a hostile witness after he's convicted?
They could subpoena him to testify. I mean, now
But he doesn't have to cooperate.
No.
What are they going to do to him if he's?
Well, I mean, not
in
if he's
prison?
already been convicted,
Gotcha.
right?
Yeah. Good point. Good point. Rick, who did we have on 10 and 11? I'm sorry, I missed those. Caller on 10. Are you there? Is it Florence? Are you there, caller on 10?
Ellen.
Ellen. I'm sorry, Ellen. And Rick, who's on 11? Go ahead, Ellen.
I just like to have a couple of comments.
Okay.
But the first thing I would like to do is offer my condolences to the Kaufman family. Caitlyn seemed to be a beautiful young lady. She was not only saving lives, she was visiting her patients on her off day. So I just like for them to have my sympathies. But my comment is, I just want you all to know that every one of these children that join gangs or grown-ups or whatever, they don't join gangs to be murderers or to kill somebody. A lot of them join gangs to be loved because they don't have anybody to love them. They want to be loved and they want to belong to a family. And they join for that reason. And one other thing that I want to say, and this concerns Mr. Cowan, I don't know what his reasons were for not going to the police and telling them what happened, but I do know that there's such a code in the black neighborhoods, and I've read The Black Sun myself, but it could have been, and I can't speak for anybody, but it could have been the fact that people say a lot, snitches get stitches and belong in ditches. So he could have not told because he was afraid for his own life.
Sure.
So that's my comment.
Okay. Thank you, ma'am.
Thank you very much.
She raises a really good point about people may join gangs because they want to have a sense of belonging in your family. So that's what valid points.
Yeah, I mean, it's the culture of it, and I don't think there's any doubt. I do get the sense that Hill was trying during his testimony, if nothing else, to be very clear that Cowan did not have involvement. He's either telling the truth or he's lying and trying to protect him, one way or the other. Okay, I mean, that's clear.
Because she's right. If he's going to prison, snitches get stitches kind of thing. The last thing he needs to do is snitch on a fellow gang member.
Okay, let's go next to Mildred. Mildred, good afternoon. Hi, Mildred.
Hi, how are you, Nick?
Yeah, good. What's on your mind?
Okay, Nick, I was going to ask the question, or I was going to give you a comment, and I did hear it prior to mine.
That's all right.
Yesterday, Hill did lean over, and he pointed to his first finger and his pinky finger to the juror, and he pointed out two different people to his attorney, and his attorney shook his head. Okay, I do believe those people know him as a person. And second, everybody has stated that Caitlyn died on that interstate by herself. She did not. She was in the faith with Jesus, and Jesus took her home. And that being said, that's why she had the option of being able to move that car over safely. Jesus moved that car for her.
Okay, thank you, ma'am.
We were talking about not the metaphysical, but the actual people that were there.
Yeah, yeah, right. And there, people driving by. It took a while for them to find her body on the side of the road in the car.
But they could have been sleeping. Okay, the jurors could have been sleeping. Could have pointed out, said, "Look at those two sleeping."
That's what I'm gonna say. Here's the thing: we don't know. I guess you assume he was pointing, and I didn't see this toward the jury. I don't know. Maybe it was someplace in front, but we don't know what he was looking at, and we can't assume that means that. Yeah, they could have been sleeping, or he might have said, "Look, they're taking notes," or we don't know. I think it's a leap to say that he's pointing, and that means he knows them.
I mean, it's like it's an insane leap. It's a big leap, to be honest with you. I don't know that, especially if he knew them and he thought it was going to be favorable, the last thing he would do would be point that out.
Right.
You know, I mean, if his buddy's up there or somebody from his family, like, hey, there's my aunt, and I graduated, 5th grade with him.
Yeah.
I know him too. I mean, they're not going to do that. I mean, it could have been that maybe they weren't there, or maybe, hey, both of those jurors are sleeping, or both of them aren't paying attention, or look at them shaking their heads.
Could have been anything.
Could have been anything.
Could have been anything.
But I doubt it was that they know one another.
Yeah, I'd be very surprised at that. Let's go next to Sherry. Sherry, good morning. Hi, Sherry.
Good afternoon, Nick.
Good afternoon.
I have a question just in reference to the jurors themselves having issues. Our buildings are smoke-free now, and the jurors that do smoke, do they have to go off the property? Do they have a designated area that they're allowed to smoke in, or how often are they allowed to leave? I'm just curious, as of not being a juror, how that could affect someone that is a habitual smoker.
So they've got a separate smoking room where they go, don't they, Nick?
You're not supposed to smoke in the Davidson County.
Is there a place these smokers can go then?
Yes, there is, and I'm not going to say where that is, but it is an outdoor place that they do go and smoke. Now, they go and smoke with a court officer, possibly even 2 court officers. And the court officers out there, to protect them, to make sure nobody tries to talk to them, and moreover to make sure that they don't talk about the case. But one thing that we have a really good court staff here in Davidson County. If you go to some of these other counties, you will see a criminal jury. I think if you remember in the Joe Clyde case, when they would go across the street and eat. I mean, they kind of would walk around the courthouse by themselves. And so these people that are in the Davidson County Birch Building on jury duty, when they are impaneled, and especially when they're deliberating, they really keep a close rein on these individuals while they're in that courthouse, because they want to make sure that nothing interferes with their thought process and that they're following the judge's instructions.
One of the folks on Facebook takes note. Debbie says that it was right after the 2 jurors were released that he pointed toward them. And so this could have been at that moment he was pointing, those of the 2 have been excused. If she notices that is when that occurred, then
that's good. That's a good eye.
That makes sense to me.
And the worst part about it, though, is that when you don't know who you are as an alternate, there could have been a juror up there that was taking copious notes and maybe gestured, and you thought they were on your side, they were on your team, and all of a sudden they get dismissed, and
all
you're
of
like,
a sudden, you lose. Are there attorneys that, as they go, maybe feel as though they're making connections with the jurors, a nod here, a smile there, and they think that that's someone that they're getting through to, and then when they get excused, that the jurors, the lawyers notice that.
Oh, sure. And it's important to point out, like, whatever's going on now, once they are no longer a part of this jury and the judge dismisses them from their service, they're free to come on morning line.
Sure.
So at some point we may find out exactly what was going on if any juror is willing to talk on or off the record to any of the reporters.
Naia is here commenting on to someone else about the fact it's taken this long could be good. You and I both agree, I think. The longer this goes on, the better it is for the defense.
100%.
Yeah, and I agree with that. That makes sense, the longer. Let's go next to Sharon. Sharon, good afternoon, Sharon.
Yes, hi guys.
Hi.
You might have already answered this question, but since they're being tried together, can their charges be severed? Can they find a hung jury for one but not the other, or do they have to have something on both?
They could be hung on one and not the other. They could find one of them guilty of the most serious offense and the other not guilty of anything, or they could find one of them guilty of the least serious offense and the other not guilty of anything. And so they can be hung as to one defendant and enter the judgment or verdict on the other one that they have a verdict on. So that's correct.
Just a reminder, an awful lot of people following us waiting to see if something goes down. I mean, here we are right now at 2:42 in the afternoon. The jury was brought into the courtroom just a little bit before 2 o'clock. It's first we've seen or heard from them. Not for a verdict. No verdict in place. The judge just quickly, Nick, just in case, do you think you could read that again, what it was, the judge? I want to listen even more closely. Okay. We tried to get as much as we could on, but this is what she read to the jury in its entirety when they came in, and that's basically all that happened.
Again, this is from the book of pattern jury instructions, and this is the criminal book that the judge has to go through. It's a pretty thick book, and pull out the correct. It has a jury instruction for every criminal charge we have in the state of Tennessee. but a lot about, deliberations and the like. And so what the judge read, she did what was called, and it's not a real legal term, but they call it a dynamite charge. And so when you get word that deliberations are deadlocked, you could call the jury back in and read something like what I'm about to read to you, but very analogous to this. But remember that this is already in the jury charge, but the judge is kind of pointing out again, and whatever judge, and this is an older book, but again, whatever Judge Dalton read to them, and this is an older book because these things are like $1,500 for two.
Oh,
it's kind of
wow.
crazy. Isn't that
Really?
weird?
I didn't know they were that
crazy.
expensive.
So it says, it is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to your individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced that it is erroneous, but do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purposes of returning a verdict.
Wow.
So again, now it's clear as mud, right?
Yeah. I mean, it's like take into account, but if you have your conviction, stick to it.
But whatever you do,
tricky.
don't surrender it just to get out of here.
Right.
To arrive at a
So
verdict.
my takeaway from that pretty much is consider, listen, be fair, try to be impartial, make up your mind. But when you do and you're convinced that what you've decided is what you really believe, you don't budge.
I think that's well said, Nick. I think you're exactly right. I think what it goes to is that I'm just not guilty. Not guilty, I'm not moving. I'm not talking about it. Not guilty, I'm not talking about it. And I think what that goes to is exactly what you say. Hey, you need to have this discussion. Re-examine this evidence. Talk with your fellow jurors about their perspectives. But don't do anything that is going to cause violence to your independent judgment.
Gosh, that's tough. And I can see why that could be a real issue if your only options are guilty or not guilty. But the key here is you have these lesser included offenses, which gives you an opening to say, look, all right, I think he's innocent, but he thinks he's guilty. We're not going to come together at that. But maybe we can meet in the middle and settle on something else. And I've seen cases where that clearly happened. Mary Winkler going a long time back. That was to me, I don't know, Google it, Mary Winkler. That was a compromise verdict.
Well, so I kind of have a sneaking suspicion, and maybe, again, this doesn't mean that it's true, but if they thought Mr. Cowan was guilty, if everyone in that room thought Mr. Cowan was guilty, I think they would have a verdict. Okay, I think they could they could find some lesser charge to agree upon.
Okay.
I think that there may be people in that room that think that the state hasn't proven anything and that Mr. Cowan is not guilty.
Interesting.
Okay, because if we all believe that he's guilty, it seems like it would be easier for us to arrive.
That's a really good point.
So at this point in deliberation, I'm thinking that maybe you have a couple of holdouts that say, look, they just didn't prove anything to me beyond a reasonable doubt of his guilt. Nothing. Absolutely nothing. We've heard nothing. We heard that we haven't heard anything about him aiding, soliciting, or attempt to aid or solicit. We haven't heard anything about that. To the contrary, the only real testimony that we have, who was really there, if you believe him, is Mr. Hill said he didn't know anything about it. So where I'm sitting right now, he didn't go tell the police. He didn't want to tell on his fellow gang member. Snitches get stitches. He was scared. Okay, but again, he did not have any sort of role. And just because they have a picture of him in front of a vehicle that they say that he was in, and Mr. Hill says he was in, that was actually the name of another person that was subsequently caught on fire, doesn't mean he killed him.
What about if he did pull up to get parallel with her to set it up?
We don't know that.
Well, you know
the
that they were parallel.
The state wants you to believe that.
Meaning we don't know if he purposely accelerated or they just naturally came up. We know for a fact that they were parallel. That's factual. There's no other way that bullet goes in her shoulder.
But it doesn't
so there's
say,
a point where Hill's here and she's right there. Now, did Cowan position him, or was this just them going and it surprised him that Hill did that?
They're clearly looking at the evidence, and they're not making inferences based upon what they did in here, and that's really where the guilt would come in a lot of ways. I'm not here advocating that Mr. Cowan is not guilty of anything, but as a lawyer, you got to look at the state's evidence, and the state's case is weak on him, and it's not the state's fault. I mean, they're doing if it wasn't for Mr. Odom, we wouldn't even be here. We wouldn't even have a weapon right now.
Okay, and I'm just hearing from our court photographer that something's up. So we're going to stand by. There is a seal still up in the courtroom, but he's giving us an indication he's outside there waiting. So that means
I have information that they have a verdict.
A verdict. Okay, on both.
I don't know.
Okay,
I don't know.
We're hearing that there may be a verdict. They're about to call them back in. This would be just about 45 minutes after the judge brought them into the courtroom and reminded them of their duty to, take a moment and consider someone else's opinion on this. So we'll see. The big question then, Nick, will be, is this verdicts for both? And they definitely could be different verdicts, okay? It could be different, completely different. Or is it going to be just a verdict for one and not the other? And Nick will be checking on that. So we'll see in just a moment. Keeping in mind the charges, first-degree murder is what they're both charged with, but the other options, second-degree murder, facilitation of first-degree murder, facilitation of second-degree murder, voluntary manslaughter, reckless homicide, or criminally negligent homicide. Those are all the options, and then, of course, the last one being not guilty. So they've gone through all that, and how interesting that they just went back in. It was about 1:53 that they were called in after being in all morning long and having their lunch. And the judge read that, Nick just read a moment ago, the reminding the responsibility of the jurors. Maybe that got through to them. Maybe they worked something out. And maybe they're coming out, as we said, with just a verdict on one of the defendants. Maybe it's on both of them. And we've got it all worked out at this point, which will have been about 10 or 11 hours after. Are you learning anything new?
Working on it.
Okay, you keep working on it. While you do, I'm going to take another phone call as we wait to see something happen in the courtroom, and we'll go next to Debbie. Debbie, good afternoon. Hi, Debbie.
Oh, this is Granger.
Oh, I'm sorry, Granger. You go ahead. My mistake.
Okay. Yeah, I've got 2 points for you to consider. Yeah. Number one, I bet you that one of those jury members has a firearm. And if you listen to that expert from Memphis, he emphasized how fast you could pull the trigger. Then in the defense for Hill, I think, emphasized marksmanship. But they never talked about how fast you could pull the trigger and hit something. And now we got 2 cars going along. It's in the 70-mile-an-hour range. I think there were probably a lot more shots than 6 to hit it 6 times. And I think that would work against the idea that Cowan was innocent, because he would have to maintain that position to be able to hit something so well. That's the first issue.
Okay.
And the second one is, I want to ask the other Nick.
Yeah.
In the reading of the jury stuff, they emphasize this happened in Davidson County. Why can't that defendant say, no, I didn't kill that person in Davis County, I was in Wilson County? And how do they prevent that from happening in the courts? Because I'm sure there's a mechanism there so somebody can't just use the procedures.
Yeah, just use
that's it.
Right. And Nick stepped out. I don't know specifically the answer to that. As far as your first case, and Nick will be back with us, he's doing some checking, trying to get some leads on exactly what's going on over at the courthouse. But yeah, I think there's probably a very good chance that some of the members of the jury are familiar with firearms, may even own some themselves, and have some experience with what it takes to fire around that quickly, one after the other after the other. And certainly you bring with you your personal experiences when you're in a jury room, and you take that into account. So I think that's very possible. Let's go. Now I think I know where Debbie is. Debbie, are you there? Go ahead, Debbie.
Hey, Nick.
Hey.
Great coverage, and I really appreciate it. My question is this. If you've ever sat next to somebody or stood behind somebody that shot a gun, the noise is so loud, it rings in your ears. And if I were driving a car and somebody shot out the window, I would immediately reach and grab them and go, "What are you doing?" And I would stop my car. I would pull over to the side. I would not speed ahead and let them keep shooting.
Okay, yeah, and that's what you would do in a circumstance. I can't say for certain. I mean, assume this maybe, if that starts happening and someone's shooting like that, would that not frighten you, and you're afraid if you intervene that person might turn the gun on you? I don't think that would have happened in this case because Hill and Cowan were friends, but it's really hard. I believe what you say, but it's hard to put what you said you would do on what Cowan did or didn't do. Again, as I said a moment ago, we all have our own personal experiences and how we will handle something. Cowan certainly knew that his friend sitting next to him had a gun, because there was testimony that the weapon was uncomfortable on Hill's hip, and so he took it out and he laid it on his lap. So the gun was right there. Cowan had to know it was right there. Did he know he was going to shoot? Hill says he didn't. Let's go next to Donna. Well, we lost Donna, so we'll go next to Lynette. Hi, Lynette.
Oh, hey, Nick.
Hey.
Yes, I just wanted to say that I was going through a trial like this and me hearing a judge say, Judge Wyatt to be exact, say that due to you're not doing anything in what took place of what you're being charged for, and that since the law has changed, we will have to charge you with criminal responsibility. So I feel that with Hill being admitted to what he's done and whatever charge that Hill will get, I feel like the Cowan would be charged with criminal responsibility on the back of that.
You think a lesser charge? You think a lesser charge would come for Cowan? Okay.
No, it would be a lesser charge for Hill, but whatever Hill is charged with, Cowan will get criminal responsibility for that.
Okay. So you think Hill might not get first-degree murder, and Cowan would get something a notch below whatever he gets, is what you're saying?
It won't be a notch below. It would be the same.
It'll be the same. Okay.
He would be charged with criminal responsibility with him being there.
I see. Okay. Gotcha. If you're convinced that he was there and that he was somehow involved in participating in what ultimately went down, and we will see. Looks like they may have a verdict for at least one of the defendants, and our photojournalist there in the courtroom says that something's going on. They may be calling them back in, but we don't yet have. Typically, if they have a verdict, and in this case for both of them, word spreads very fast. We have a verdict. Get everyone back here. Get in. We're all set to go. That's the way it's gone down in every single other trial we've done. In this case, they're panning out now, and we haven't heard one way or the other. Let's see. We'll listen in. No one's there yet. Judge is not in, but we're zoomed out, and we'll get a handle on what we've got here in just a moment. We may have a verdict on both defendants, or just one, or it's something else.
I believe we got a verdict.
Okay, for both of them?
Don't know, but I know we got a verdict. So, I mean, I clearly think if they're not going to call everybody back in if they just got a verdict for one. So they must have a verdict on both.
All right.
They must have a verdict on both.
May well have a verdict on both of them, and they're all coming back into the courtroom, so we will see how this plays out. Typically, the jury will come in, and the question from the judge will be, have you reached a verdict? And they'll say, yes, we have.
They'll say, yes, we have, and then they'll say, all right, Madam Foreperson, would you stand and read the verdict? And, we, the jury, find the defense, they'll go through it and they'll read it. And of course, it only needs to be signed by the foreperson, the verdict form. But, we were talking about having jurors' lives in your hands and how difficult this can be. It's really tough when it's a death penalty case because each one of the jurors at the sentence, has to sign that verdict form. I just made a change on there about what.
Just on what some of them are. Okay. So
it's a verdict to both, clearly. I mean, because they wouldn't just take a verdict on one that quickly after they had left. So there's a verdict on both.
Okay, so that's coming to us about 10 to 11 hours over 2 days of jury deliberations. And look, the way it played out, there may have been some disagreements. There was a lot of evidence from 5 days of evidence phase. Hey, this is not as though, it was way long. We were already talking about hung juries and the judge doing something. Obviously, there was something going on behind the scenes for her to call them in a bit. But they did their duty.
Here comes the judge.
Here we come. Let's listen in.
Okay. Ladies and gentlemen, it is my, I'm sorry, I thought they were out. Ladies and gentlemen, it is my understanding that the jury has reached a verdict. At this point, I do not know what that verdict is. Whatever the verdict that is read today, I ask that you please be respectful of the jury, be respectful of the time that they've put into this case, be respectful of the time that they have deliberated, be respectful of their patience over the past week and several days. There will be no outbursts allowed of any manner when the verdict is read.
All right.
Okay, we may all be seated. Let the record reflect that the jury deliberating in this case are back in the courtroom. Madam Foreperson, it is my understanding that the jury has reached a verdict.
Yes, Judge.
If you will please stand and if you will read that verdict.
State of Tennessee versus James Edward Cowan, Devontae Lewis Hill. We, the jury, find the defendant James Edward Cowan not guilty. We, the jury, find the defendant Devontae Lewis Hill guilty of second-degree murder.
Okay, if this verdict represents the verdict of each juror, if you would indicate by raising your hand, please. Let the record reflect that all 12 jurors has raised his or her hands. Ladies and gentlemen, your time has been very much appreciated. I know that this has been a lot to take in over the past week and several days. We appreciate your time, we appreciate your patience, and we appreciate the thought that you put into this case. You may go now.
All right.
Mr. Cowan and Mr. Hill will remain standing. Everyone else will be seated. Mr. Cowan and Mr. Hill, you have heard the verdict of the court, of the jury, I'm sorry. The verdict of the jury now becomes a judgment of this court, having found Mr. Cowan not guilty of the charged offense, or any of the lesser included offenses, having found him not guilty in this case. And as it relates to Mr. Devontae Lewis Hill, the jury having found the defendant guilty of second-degree murder, the judgment has become the verdict, or the verdict of the jury becomes the order of the court. Thank you so much. We'll have to set, Mr. Cowan can step back. We've got to address sentencing hearing. Mr. Hills can step out. Yeah. Do you have a proposed time, date?
Yeah, I was we don't have anything March 3rd. Is there a reason for that?
I don't think so. That should be a good date. How does March 3rd? Does that work? All right. We'll set the matter for a sentencing hearing on Friday, March 3rd. Mr. Hill, you're receiving the documentation regarding conducting the pre-sentence evaluation. I'm sure your attorneys will go over that form with you. All right. Thank you so much. If there's nothing, yes, sir. Oh, yes. Oh, for Mr. Cowan, the judgment for Mr. Cowan. Can you get that, Doug, please? All right. If there's nothing further, court is adjourned.
The verdict's in, and we watch now as the families file out of the courtroom. First, it appears as though, and there are the parents of Caitlyn Kaufman, and you have to wonder, they have to be disappointed in the verdicts. On the other side of the room, the family, certainly of James Cowan, have got to be thrilled. A not guilty verdict for him, not guilty of anything. And then Devontae Hill, a lesser charge of second-degree murder, not first-degree murder, and the prosecution walking out now with the family.
I'm shocked at the verdict, I'll be honest. I was shocked. But I told you that this deliberation was going so long because of the fact that they were thinking not guilty on Cowan.
Mm-hmm. Yeah. And you were saying all or nothing. I thought that clearly Cowan was going to be lesser based on what was happening, and here comes Cowan and Hill's family leaving the courtroom.
And so Mr. Cowan will be going home tonight, unless there's something else holding him. He may have a probation violation or something.
He's been locked up the last 2 years.
Yeah.
He's been locked up the last 2 years, and he will be going home tonight, unless, again, keep in mind, as far as we know, he has some other legal things that he's dealing with, but I'm not sure if
I'm sure the state's not going to give him a deal on that.
Yeah, he has some, and he has apparently some federal charges perhaps pending, but he's going home, found not guilty of anything. And then second-degree murder and what that tells me, with the second-degree murder on Devontae Hill, of course, he admitted that he shot and killed her, but he said that it was in the heat of the moment, and the jury believed it, that it was not premeditated. He was angry, he was under the influence, she cut him off, and he shot and killed her. He admitted it, and they decided it was not a premeditated murder.
And they're going to have, so right now, all that Mr. Hill could possibly face, he has, the juvenile stuff came in, but, again, this is the guy that tried to kill his grandmother and a 6-year-old and 12-year-old child, but they came back with the knowing killing of another and second-degree murder. But based on the fact that he doesn't have any, felonies out there, he's looking at, as a range one offender between 15 and 25 years. And at the sentencing hearing, which you heard the judge give the March date, the court would start at the midpoint, which is 20, and either go up or down based upon enhancement or mitigating factors. But one thing they're not really going to be able to do to increase his sentence to that 25 mark too much is the fact that he doesn't have a whole lot of priors, and he's got 2 years of jail credit on this. But
he's eligible for parole at
no, he's got to serve. I think it's 100%.
It's 100%. Right. So let's just say the judge ends up giving him 20 years.
He's got 18 left.
He has 18 left because he's been behind bars. 18 years. He can't. Now he can earn good time credits and get out sooner than that, can't he?
I mean, not on the 100%.
Second degree murder.
Not on the 100%.
It's 100%. But that's a lot different than life in prison.
Yeah, I mean, and I tell you, you almost saw Mr. Ron Munkebo cry when they announced not guilty. And, as a lawyer, that's certainly a victory for, the defense team here.
I mean, I don't know what Munkebo would say in a candid moment, but I think this is probably beyond what even he had expected. He hoped for it.
I think you're right. I think everybody's shocked. I think the judge is shocked.
When I heard not guilty, I mean, he was driving the car, but to say that he had no responsibility whatsoever for this, and that's what the jury came back with. But, and I can see that's what they were debating. And what this tells me is whoever felt he was completely not guilty was able to sway these other folks. They didn't go in a middle ground here. I mean, apparently these others agreed, okay, not guilty. And
like I said, I thought that's where they were. If everybody had agreed upon guilt, we'd already had a verdict. I think that we had some folks that were, maybe it was split, that believed that he was clearly not guilty. It's not the fault of the state. The truth of the matter is, and I've always said, and I've said this throughout the case, that they didn't have a real strong case against Cowan. If you took the proof, what they had proved to you, they didn't have a strong case. The end. They didn't have a strong case against Cowan. They just didn't.
You said that from the very beginning, and the jury apparently, it's just amazing to me, just the circumstances. And you heard me say, I think I came around the more I heard in this trial that it was going to be something lesser than what Hill got, but that there were 12 jurors in there, 12 jurors that agreed that he's entirely not guilty.
Yeah, 12. Well, obviously they didn't at first, but they were able to bring those two around.
It's just entirely not guilty. And the word of the jury, and that he is not guilty. He is not guilty. And as far as for Hill, that is a victory for him. Absolutely no question. You're saying 18 years. That's rough, Nick. Yeah, of course it is. But boy, he was looking at life in prison with no possibility of parole. He'll be out. He's 24 years old. He'll be out in his mid-30s. Mid-40s.
So, in all the trials we've covered, we've never really seen a verdict come back this, defense-oriented. I don't think we've seen a not guilty. I know we've never seen a not guilty. That's the first time you and I covered gavel to gavel. We've seen a not guilty.
The first time. So I'm asking you, as the prosecution walks out, and Caitlyn Kaufman, and let's not forget again in all of this, this young woman lost her life in horrible circumstances. What on earth's going through the prosecution or the family's mind?
Well, I don't know that it matters if they got 150,000 years. Ms. Kaufman's never coming back. She's, and so I know that, there's a sense of not maybe having the closure that you wanted. Clearly I do think that Mr. Cowan was it had a role in this. And I think we all would agree he had a role.
Well, except for this jury.
Well, but again, the question is, did they prove a criminal act? And obviously, that's the difference here, is that the state just didn't have the proof on him.
He had a role. He was definitely driving, but did he do something criminal?
Right.
And they believed Hill when he said that Cowan had nothing to do with it. You heard his attorney say he didn't shoot, he didn't have a gun of his own, he was driving, he didn't know this was going to happen.
Right.
Does any of the factors come into play after the fact? You mentioned it before, how much so the fact that he did not call 911, he did not go back to try to provide medical aid to her, that they covered it up. Does any of that?
Well, so I mean, the state's got the burden of proof. The defense doesn't have to do anything. But again, what they didn't show that he threw the shell casings out at Sharondale. They didn't show that, yes, that was his car and he intended to go burn that car in an effort to secrete evidence. Didn't have that. We had Hill giving the gun to Odom, not Cowan being involved in that, okay?
Right, Cowan was not, Hill had the gun.
Right. So I mean, again, it was just a very thin circumstantial case as to Mr. Cowan. I mean, it really was.
Yep. Okay. And that's what the jury, and they abided by the rules in there, and that's how it played out. Keeping in mind, when you're on the outside looking in, you watching at home and us with everything else we know a lot more, including what the sentences are and everything else, than what the jury knows. They can only base it on what they hear in the court.
That's right.
And so, you have to trust in what this jury did. It's the system. And they came back with not guilty. And this is got to be a very, very satisfying day for Mr. Cowan, because I think
and Mr. Hill, I'll be honest, and Mr. Hill.
Well, and I'm telling you, I think Cowan had to be surprised. I think Hill thought second-degree murder. He had admitted that he shot her.
I thought that was the very least on Mr. Hill. I did. I thought that was the very least that they could arrive at, was second degree on Mr. Hill.
Me too, and that's what came down. So, fair enough as it stands. Just a reminder one more time with regard to Mr. Hill. He will be sentenced on March 3rd, and the judge, because he's a range 1 offender without any serious felonies on his adult record, will be looked at between 15 and 25 years.
And I'll start off at the 20 point. But it's important. I always tell my clients too that in a situation like this, if the state makes no offers and they just other than plead to first-degree murder, we have nothing to lose by going to trial. But this is a prime example that you never know what you're going to get from a jury. You never, ever know what you're going to get from a jury, do you?
Well, I said as much. When this first went, I had more than a few people say, Nick, why is this even going to trial? We know they were involved, blah, 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 blah. Why isn't they? I go, well, listen, the DA is not going to offer them any type of plea deal. Okay, so if you're sitting where they are, I'd do the same thing both of them did. Let's go to trial. You never know. And look at this. I wonder, had the DA gone to Cowan with a plea deal when he was looking at life in prison without parole and a first-degree murder charge, I wonder if he would have taken it for something, say, for a facilitation of second-degree murder or voluntary manslaughter.
Absolutely. I mean, listen, when you have a client, I have these kinds of cases, and when you have somebody charged with felony, I've had a few felony murders recently, and when you have a serious charge and someone's facing life, and then the offer is, plead to this, and you might get 8 to 10 years in jail. I mean, that's a huge thing to walk away from, because once the jury comes back with that verdict and that gavel falls, you can't go back and take the deal if you don't like the verdict.
Yeah.
So in those situations, it's really, quite honestly, it's hell for the defense attorney and the same for the client, because you don't know what to do, because the numbers come up so big if you lose.
Yeah.
They come up so huge if you lose.
Oh, if I were in Cowan's shoes at that point, I probably would have taken it also. And I don't think he would have dreamed that full acquittal, which is what he just got.
But I thought that's where we were, because if everyone thought there was culpability, they should have been able to arrive at a verdict a whole lot sooner. So I felt like there was some people in there that, and actually it was probably the majority of people were feeling that he was not guilty.
That's right. All right, let's see what you think. We're going to take a few calls here and make our way through this. But once again, just if you're joining us, the verdict after 10 hours of deliberation in the Caitlyn Kaufman trial, Hill, the shooter, second-degree murder, looking at between 15 and 25 years, 100% in prison. The driver of the vehicle, James Cowan, found not guilty. What do you think? We'll take a call from Jim, started off. Jim, good afternoon. Hi, Jim.
Hi.
Hey.
I am shocked, and I have a couple of questions. One of you mentioned about there was no jury. I think they called it a bench warrant. How would that case come about without a jury? And would that be maybe
a bench trial?
A bench trial, yeah, less risky. And the other question is if they would have been tried separately, so that perhaps you wouldn't have had any testimony from Hill, would that maybe have served a different outcome? I mean, I know it's kind of, and why the decision to combine them? And the fact is that Hill testified, I mean, I would have to say the quality of testimony from criminals, I guess Hill's past wasn't known because of juvenile status, but also the other wasn't included. So there was a lot of missing information there, but I guess I understand you're calling it a weak case, but wow, the disappointment is just tremendous.
Yeah, a bench trial, that's where
either one of them can have a bench trial at any point in time.
They could have called for it and said, we'd rather have a bench trial than a jury.
That's up to them, you know, and then the judge would have been the trier of fact, and the judge would have been the one who decided guilt or innocence. But clearly on these kinds of charges, I mean, if you have a DUI charge or if you have a good defense to it, I mean, I've had bench trials in front of judges because, you know, the facts are pretty good and you know you're going to get probation or you're going to get some sort of diversion and you just kind of hurry it along to get an expeditious resolution of something because the state's being difficult and won't agree, you know?
Sure.
But otherwise on a huge charge like this, you always have a jury trial. Could they have tried them? They wanted to try them together clearly because they didn't have a lot of proof on Mr. Cowan, and they needed to dirty up Cowan with Mr. Hill. They had no idea Mr. Hill was going to get up there and say that, but they had a lot more on Mr. Hill. They would have been forced to try them separately if there were brutal issues or where one defendant was going, they were going to use a statement of about one defendant's involvement against another defendant, you know, so with co-defendant statements and like that and the like, and the constitutional rights that surround the problem with the right to remain silent versus confronting witnesses. If they had that problem, they would have had to sever them, but they didn't have that problem. And if you remember, there was one statement by Mr. Odom that rather than sever, the state says that's fine. We'll just take out the reference to duty.
Yeah.
Okay, and they did, and they took that reference out. But they clearly, if they were to have severed them, or if they were to have tried them separately, I don't see how they could have gotten a conviction against Cowan.
Do most defendants want a jury trial?
On a severe charge like this, and it's a prime example. It's a prime example of why you want a jury trial because, no offenses to judges, but judges are elected, and so sometimes judges have to make difficult decisions. But you know, they have other considerations. A juror doesn't have any considerations. You know, the juror is not going to be on the front page of the paper for letting somebody go that commits a crime in the future, but the judge will be.
Excellent point. And real quick, it doesn't appear as though we were right when it came to Hill's testimony. I mean, we thought, it didn't go necessarily well, but I think if the jury believed him, Hill's testimony, I don't know how much it did to help him, but I think it apparently helped Cowan, don't you think?
Yeah.
I think it helped Cowan. I think they bought into it. And when he said Cowan had nothing to do with it, they bought into it. They believed him to be credible. And I think Hill's testimony helped Cowan. Not sure how much it helped him, but it helped Cowan.
Yeah.
Again, keep in mind, he never once during his testimony showed any sign of remorse. And I guess that did not bother the jury. The jury stuck to the evidence.
But I also think, too, that, you know, again, the jury system is the finest we have. And I mean, and people have fought and died and continue to fight and die to, you know, make sure that this system stays intact in America, and it's the best system around. It's got its, you know, certainly got its problems, but you know, again, you know, you never know what you're going to get from 12 jurors who hear that, you know, and you saw today that you know, the outcome was really good for both of them, quite frankly.
Look, there are a lot of people right now on Facebook and everywhere, you know, responding to this, and there are a good share that agree with this verdict. I haven't seen a ton saying that they agree that Cowan was completely guiltless, but there are some. But the vast majority are asking themselves, what on earth happened with this jury? And again, these are 12 people, a jury of our peers, and they're the 12 that made it through a 2-day jury selection process signed off by the prosecution. You know, I mean, that's the best we can do. You have to live with it, and they made their choice, and I accept it.
The only thing the state could have done any differently, and of course hindsight's always 20/20, and it's easy to sit here and be, you know, Monday morning quarterback, but I think jurors a lot of times, and we have this with callers, they think premeditation takes, you know, this is something I sat around and plotted and thought about for weeks, and that's premeditation. And you know, and the secretion of activities, you know, could be evidence of premeditation. The state could have hammered on that a little bit more, because I think the callers and other people think premeditation, they don't realize it's something that could be formed in an instance, just in a matter of a nanosecond. You can premeditate, okay? And so I think that there's a lot of confusion on really what premeditation is. You know, we think premeditation is I'm planning to kill my spouse and this is how I'm going to do it, and you know, and I get people involved and it's a real long drawn out thing. But the reality is there's lots of ways to look at premeditation, and I think if there's anything else the state could have done would have been hammer that home, what happened afterwards to try to cover it up, and you know, to really hammer home this premeditation issue, because clearly I think that's where the jury got hung up.
Let's take a call from, I think, Diana. Diana, good afternoon. Hi, Diana.
I'm good. Thanks for your coverage.
Sure.
I just want to make one statement and maybe have a question. My statement is that just because James Cowan was found not guilty does not mean he is innocent. He does have some culpable responsibility for what happened. And it just shows that our justice system is that they didn't have enough evidence to prove that for him. But he will go his whole life around town, you know, as someone that helped Caitlyn Kaufman's killer. You know, just because he didn't shoot the gun doesn't mean he's not culpable. And my other question is, since he is already a criminal or has a felony, does he not get charged because he's in a vehicle with somebody that has a weapon?
Well, he was found innocent of any wrongdoing in the vehicle, so that doesn't come into play at all, does it?
No, I mean, and right, wrong, or indifferent, like it, love it, hate it, whatever it may be. I mean, Mr. Cowan has now been adjudicated innocent, and that's what the man is. I mean, not guilty. And she's right. There could be a difference in innocence and not guilty, but the jury's spoken, and that's where it stops. I mean, and that's where it rests. I mean, you know, they found him not guilty, and that's the verdict of the court. That's the judgment of the court at this point in time. And just like, I hate to go here, but I mean, you know, O.J. Simpson's not guilty, right? I mean, you know, that's what the jury said, and no matter what he says, I guess one thing I would wonder, though, is that we do know that Mr. Cowan has an extensive criminal record, okay, and he's not finished with that. And so I just wonder if this was enough of a jolt, you know, this being on trial for something like this, if we see him back in the criminal justice system anymore.
Yeah, we thought there might be some gun charges, federal gun charges. He is a convicted felon?
Yes.
Okay, he was photographed holding a gun at a party 2 days after Caitlyn Kaufman was shot. Is that something that prosecutors could take note of in other cases?
Yeah, and it makes you wonder, too, if that were to occur, if all of a sudden here comes an indictment for felon in possession of the weapon by the feds, you know, clearly we know how that happened. Right? I mean, it doesn't pass the smell test. I mean, clearly that would be a violation of the law for him to be in possession of a firearm while he's a felon. And here's a picture of him. But again, you know, that could very well be, you know, piling on just because they didn't turn out their way today.
Okay, yeah, it's interesting as we sit here. I mean, he was fully acquitted. The other defendant was found guilty of second-degree murder. But this, as the DA's office walks out, they lost here.
Yeah, I mean, I think they would say that they lost. I think they would admit they're disappointed with the jury's verdict. But, you know, they don't always win. The defense doesn't always win. This is the first one that we've covered in probably the 15 trials and the years we've done this where the defense wins.
Yeah, it's true. And it's going to happen. And it came down, as you said, especially with Cowan, the evidence. You got to have the evidence. Let's go next to David. David, good afternoon. Hi, David. Are you there, Dave? Oh, he hung up. Let's go next to Jim. Jim, good afternoon, Jim.
Hey, how you doing?
Good. What's on your mind?
Hey, so I guess like the other Jim, I'm shocked, disappointed. I thought they were both guilty of first-degree murder, and you can bet right now in the Crips club, they're hooping and hollering and jumping up and down glad over this. This just tells you that you can be a driver in a drive-by shooting. You there?
Yeah, go ahead.
Yeah. It pretty much tells all the gang people in Nashville that you can be a driver and get off of anything. And that picture 2 days after they murdered her pretty much says it all. I mean, all you have to do, the common sense of people on the jury, I've served on 2 juries before. I've been in law enforcement. I'm retired 24 years. And all you need to do is go watch any of the gang stuff on YouTube, on the internet. It's all over. Gang members are ruthless. They don't think 2 seconds about human life. They don't value it.
Okay, but that's going elsewhere. We're not going to debate the issue with gang members. And if the gang aspect of this case had a bearing, it did not play out. It was brought up by the prosecution on more than one occasion. We heard about the cake, we heard about the party, we heard about them being gang members, and that they both are. And Nick, I don't think it made a difference. I don't think it did. And in fairness, I don't know that Caitlyn Kaufman's shooting and the act of this had anything to do with any kind of gang activity. It seems like
well,
these two
to the
guys,
contrary, the proof is that it did not.
It did not. I mean, it was that she cut him off. It wasn't a gang member. They didn't know her. It was completely unrelated to gang activity and didn't play a role. Now, I know someone like this last caller will say, well, the reason this happened, at least with Hill pulling the gun, because he's a kind of guy in a gang and he does something like this. I don't know. The jury didn't see it that way. So let's go next to Linda. Next on the horn. Linda, good afternoon. Hi, Linda.
Hi.
Hi.
Man, I am so disappointed. I'd like to make 2 statements. First of all, I feel so bad for the family of Caitlyn. I mean, that's like killing their daughter all over again. They've got to be just devastated. And also, Nick, I think within 6 months or less, you'll be doing another story on the other guy, Kaufman. He probably will have another victim since he's out now.
Well, I don't know. I guess we'll see. I
mean, he has a lengthy criminal history, but I would think if
there's a wake-up call, this should be for him.
Yes, having gone through this experience, I certainly think that you might, if you found, God and you want to change your life, I think this would be a wake-up call, sitting there thinking that, you might never see the light of day again. So hopefully, he will change his life of crime and, turn around.
Unless something else comes up, though, and you said maybe something is, we don't know what else is going on with the case against him. He should be a free man tonight.
Well, I don't know. He's got some other cases out there that I don't know that have been resolved. He had a 2021 arrest with the crooks with guns, which it says that he had enough drugs, over a felony amount of drugs, that with his intent to sell and the fact that he had a firearm on him does carry mandatory jail time with it. Not a lot, but he's still, so I don't think those 2021 charges are resolved yet. So, and
could they hold him, but maybe he'd get a bond? Because he has been locked up the last 2 years.
No, I mean, clearly, so this case is over. So if he was on bond on the other, you certainly get a bond on the other charges. He probably has a bond on the other charges as well, that it's just sitting out there, and he might ask to make bond again on those charges.
So after 2 years, he could be going home tonight.
But I don't think the state's going to give any deal on the other after this happened.
Oh, yeah. Well, we'll see. We'll follow that part of it. Let's go next to T. T, good afternoon. Hi, T.
Hey, Nick. This is Terica. It's not T anymore. I'm so sad what happened to Caitlyn's family, and I got a couple of things I want to say. I believe that he was not guilty. That was the right jury. That was the right charges. It was also the right charges for Hill because it wasn't premeditated murder. And I have a feeling, I could be off, but I have a feeling Jacques, which is the confidential informant, the snitch, I believe that he's going to get out of jail. He's going to get out of jail. He's going to backtrack and say that the DA or the prosecutors made him testify and lie. And it's a possibility that Devontae may get out. But they keep on assassinating Callan's character. He's going to go back to jail. He was in a gang. Well, that didn't prove anything today, and the right justice was served. And
well, thank you for your call. And T said as much yesterday, so I give you credit, T. I mean, you said the same thing yesterday before this came down, and you were on point on that. As far as Devontae Hill, though, we do have him on record admitting, he testified and he admitted that he shot and killed her. So that no one's making that up. I don't see how the confidential informant can say something. I mean, I think the jury probably convicted him of something here, largely on the fact that he admitted it. You do wonder if his defense went into this, instead of in opening statements conceding right off the bat that he was the shooter, could it have played out differently?
I mean, the big bet is always a good decision when you win a bunch of money, right? So, they went out, that was a huge gamble, and it paid off.
I mean, it did. I don't know if it would have been different, and maybe that's why it paid off with him taking the stand and saying what he did. So, Okay, let's go next. Line 8 is Janik, I believe. Hi, Janik. Oh, Janice. Duh, I can't read my own handwriting. Go ahead, Janice.
Hi, Nick.
Hi there.
Yes, I just have a question. What about the jury?
Mm-hmm.
Do we know the makeup of the jury?
There were 3 men and 9 women.
Okay. And I must say I was surprised at the verdict. That's all I have to say. Thank you.
Thank you, ma'am. You're probably not alone out there. A lot of people expressing surprise on that. We'll take a few more calls here and just to get some of your reaction. A lot of people just wanting, if you have questions. By the way, the defense can always appeal. Prosecution can't appeal.
No, that's exactly right.
Some people
Mr. Hill can appeal this conviction and probably will appeal this conviction. That's right, and he will. He should
appeal.
He should.
I mean, maybe, yeah. But as far as the prosecution says, oh wait, Cowan was acquitted. Can we appeal that? That's not the way it works.
And one thing we haven't seen normally this time when we're doing gavel to gavel, we're listening to the DAs and the defense attorneys. But I guess we've heard nothing from the Birch building that anybody wants to speak, huh?
Yeah. You know what? It doesn't sound like it at the moment. If they are speaking, and whenever they do, I'm not saying they haven't. It may be something where we haven't had the signal up, but that'll be in the evening newscast. So rest assured, hang out for that. We have a crew over there, and whether or not the defendant's family, Cowan's family wants to talk, we'll be glad to talk to them. Hill's family. If Kaufman's parents want to talk, we certainly would listen, and if the prosecution. So they'll be getting that. We'll see if indeed they're talking. Maybe they haven't yet. Sometimes they meet afterwards and talk it out, but we'll see how that goes. Let's go next to Connie. Hi, Connie. Connie, good afternoon. Are you there, Connie?
Oh, yeah. Good afternoon. Great job, guys.
Thank you.
I was shocked, but I just got a question.
Okay.
Do y'all think that Hill knew some of the jurors the way he pointed at them?
No, I don't think so. I think, first of all, people would observe if there was any indication he was trying to intimidate or anything. I think based on one of the other people that messaged us on Facebook, I think Hill and Cowan both were pointing and maybe observing. It came right around the time the judge excused the 2 alternates. Until that point, there were 14 jurors. The judge removed 2 of them. Who knows? Maybe it's 2 alternates that they thought those were good jurors that they wanted on there and they were excused, or vice versa. I don't know. But I get the sense they were pointing at the 2 as they were excused and removed from the courtroom. That's all I can say. But I don't believe there was any indication of any, that we've heard of any intimidation or anything along those lines. Let's go next to line 10, and that would be Bonnie. Hi, Bonnie. Are you there?
Hi.
Hey, Bonnie. What's on your mind?
Well, first of all, thank you for your coverage. It was great. I didn't miss any of it. And disappointed, very disappointed. Not even a slap on the hand. But my concern is I want to know what kind of protection that Odom will have.
Well, he's still locked up and awaiting trial.
Which is probably the most he will have being locked up.
And I don't know that they're going to go. Look, and after the fact here, I don't know how that all works. But look, I mean, Cowan was acquitted. Okay? Cowan was acquitted, and Hill can appeal his second-degree murder conviction, and he didn't get life in prison,
Yeah, but they all had to sit through that because of Mr. Odom. So, I mean, I understand. I wondered that too. I mean, there's no witness protection program like they have in the federal government or anything like that. I mean, once Mr. Odom's out of jail, he's back on the streets with no protection. And if he is indeed in a gang and he was telling on rival gang members like he was, I mean, that could cause problems for it. But he knew that going in, so I'm sure he's prepared to navigate his way through life, after having done what he's done.
All right, let's go next to Monday. Monday, good evening, good afternoon.
Hi, Nick and your guests.
Hi there.
Hey.
Hi, I was just calling in because when I heard the verdict and about the guy that got second degree and the Cowan got off. I felt this would happen because a lot of people are probably not going to like what I'm saying, but I'm going to say it anyway. Because that Cowan guy, if you think about it, he wasn't involved except for driving that car. You see what I'm saying? And then the guy that shot her, he admitted it, and it wasn't intentionally done. I think he just... I don't know what happened that day, but I'm hearing a lot of callers coming in saying they're disappointed. Wonder if that was your family. You know what I'm saying? The jury has spoken, and the answer is one's going to jail, the other one is off. You know. And you all have a good evening.
Thank you.
Connie's right about that. I said that earlier. I mean, the jury's spoken, and like it, love it, hate it. That's where we are, and that's that's the system.
Yeah, it's with regard to Hill, you're right. It's the system. It's the premeditation thing on that. 6 rounds shot into a vehicle, and that's not premeditation.
Well, I mean, it's not on this case.
No, it's not. I don't get it. Let's go to Robert. Robert, good afternoon. Hi, Robert.
Evening, fellas.
Hey.
It's like the way Connie just said, it is what it is. We got to live with the with the jury.
Sure.
But my question is for the counselor there. We all know that the law, down through the books, and with the road rage law that's on the books in Tennessee, what kind of precedent is this going to set for what we have on our laws now for road rage? It's got to set a precedent. They can go back and look at it and say, well, you had a driver. If he says, well, I didn't know anything about it, we can't tell that. So what kind of precedent does this set in the future?
Well, so it's a great question, but precedence is, and you're saying precedence, something that we would look at as lawyers and as judges to say that this is the law in the state of Tennessee. That comes from reported appellate cases, not what happens in the state trial courts when at the trial. So when something is appealed, then when the Court of Appeals issues a written opinion, and if it's published versus unpublished, then it does become authority or precedent. And the same with the Supreme Court. So what has happened here today may help create some sort of precedent on Mr. Hill's appeal. But I think the precedent is more set in negotiations with the district attorney's office on similar sorts of cases and say, well, you saw what just happened. You saw what just happened. We're willing to take this deal. You may not get a conviction, So I mean, as far as precedents, I think it's something that maybe the defense counsel would use with the district attorney's office to say, it wasn't for lack of ability. It's just that these Davidson County jurors are getting more unpredictable from the state's perspective.
There you go. Let's go next to Lawrence. Lawrence, good morning, or good afternoon now. Hi, Lawrence.
Good afternoon. My heart goes out to the Kaufman family and the loss of their daughter. But I hear a lot of... Hello?
Yeah, we're here. Yeah. Go ahead, sir.
Okay, I hear a lot of people talking about they're really disappointed in the verdict. But how do you... there's a lot of other people that are really disappointed in verdicts that when the police kill people, that they can get off. I'm not saying that this guy should have gotten off. They should have got whatever that was deemed necessary for the crime. But this thing of people disappointment, that's why you have so much rioting and protests and all that stuff, is because the jury going along with the police killing.
Well, yeah, I mean, so I hear what he's saying, and there would have been disappointment on either side. Had it gone differently for Cowan, his family would have been very disappointed. It's, there's going to be disappointment on one side or the other. That just goes without saying.
As I was sitting here, and we've covered this now for 8 or 9 days, I guess, and during this period of time, we saw what happened with Tyree Nichols.
Yep.
Okay, and we saw in that particular case, and this kind of goes to Lawrence's point, we saw in that particular case that there was an absolute mad dash to the grand jury by the district attorney to indict these police officers before they released this video, and they did that in very, very short compass. And the reason that they did that is in such short compass is because they were scared of the people. Okay, and scared of the power that the people would have if this were to air and there not be criminal charges. And so I still think that the people in America still have the power, and that's one example of people having the power. But today we saw with the jury that it's not the establishment, the courts, the police, even though we have lots of problems in our criminal justice system, lots of problems with policing. Again, today we see that in the Nichols case, it wasn't the establishment that had the power, it was the people, and that was the rush to indict. And we also see today that it's not the court system, it's not the DA's office, it's the people that have the power. So I think the thing that stands out to me today is that people in America, we still have retained power, and we can't forget that we do have the power as the people.
Couldn't agree with you more. Let's go next to Ram. Ram, good afternoon. Hi, Ram.
What's going on, Nick?
Hey, Ram, what's on your mind?
Man, I'm calling to say they did just what they needed to do. Everybody calling time out, they disappointed because they let Caitlyn Kaufman down and all that. Look, they got the shooter. Cowan ain't had nothing to do with that. It ain't no such thing as premeditated murder when somebody is pulling up on the side of the other. It ain't like he said, okay, that go Caitlyn Kaufman. You know what I'm saying? Let's get out the window and shoot her. Like, no, that ain't what's going on. Like, that's just something. That's a freak accident that happened at the wrong time, and Cowan was just in the wrong place at the wrong time. Cowan was coming home.
Yeah, I hear you. The jury agreed with you, sir. The jury agreed with you. And we've said the evidence just wasn't there. And we know that his cohort in the vehicle admitted to shooting the gun, but he said it was not premeditated. And the jury agreed and came back with second-degree murder, which means he's looking between 15 and 25 years in prison. Starting at 20, he's already served 2. Let's say he gets 20. He's looking at 18 years at 100%. And Cowan, as we know, unless there's something else happening legally for him, after 2 years locked up in the Davidson County Jail, will be going home and sleeping in his own bed.
Or shortly.
Shortly so anyway. Let's go next to Thomas. Thomas, what's on your mind, Thomas?
Hey, first thing that came into my mind is Cowan had better watch his 6. Thank you.
Better watch his what?
Location, I think.
Oh, okay. Whatever. Let's go next to
threat.
We don't need any of that crap. Let's go to Brian. Brian, what's on your mind?
Hey, it's me again. How y'all doing, Nick?
Good. What's on your mind?
What's on my mind is say that I was going down. I go down 440 every day.
Yeah.
And I've got one of those. I got a big heavy duty F350 truck. If they pulled a gun, if somebody beside me pulled a gun on me, what's to say I took my truck and I just rammed them right into the wall and just stuck the gas pedal wide open? What would they do to me?
Well, they would charge you.
No, yeah, they would charge me for and they pulled a gun on me. If they pulled a gun on me, and I'd be charged.
Well, it depends on the circumstances. So what your point is what? I mean, because that's a different scenario than what we're dealing with here.
Yeah, it kind of is. I'm disappointed that they didn't find them both guilty. The driver was definitely guilty of something. As I said earlier, if my neighbor had come over and knocked on the door and went robbed the bank down the road, I mean, I would be charged for bank robbery just like him.
Well, you know, I mean, there are people pleased with this verdict. There are a lot of people that are questioning how it could come down full acquittal. Boy, I would love to have been a fly on the wall because I'm curious, and I wonder if any of the jurors after the fact, and it's totally their choice. We can reach out to them and ask them if they're willing to talk, and they may not want to. But I'd love to know the line of thinking, the debate, and how they came to this conclusion on Cowan. I think that would be fascinating. Sometimes lawyers try to find out after the fact. What's your experience with juries? Because with mine, I found by and large, they usually are hesitant, especially right after the trial, to talk, and I respect that. But sometimes later, I've interviewed jurors, and it really is insightful.
So one of the biggest things you can do for both lawyers, the state and the defense, is that, if they reach out to you as a potential, as a former juror, you don't have to speak to them, but that helps both sides, sharpen and hone their skills, and so it's always just a fascinating thing to be a lawyer in a jury trial. And then talk to the jurors afterwards and find out maybe what they honed in on, what they didn't think was important. That just helps make better lawyers on both sides. Of course, they're under no obligation to do that, but as a lawyer, these people have, both sides of this have been, dealing with this case for 2 years now or so, okay? And they've been preparing, and so to know what it is that they did or didn't do, or they could have done better, or what they didn't think was important, but I guarantee you, based on the calls and everything we're hearing, what has hung the jury up, again, is the definition of premeditation.
Yep. That's tricky. You've worked with me on that. I think I understand it, and then I don't. It's tough. It's tough. And clearly they didn't think that what Hill did was premeditated. Let's go to next on the horn, Tracy. Tracy, go ahead, Tracy.
Hi. Thanks for taking my call.
Sure.
A point that I've noticed that I don't think has been brought up is that Phil had stated that she cut him off, if indeed that is what happened that caused this to originate to begin with. He wasn't the one driving. Calvin was the one driving the vehicle, so if that's what happened, then he was the one who would have been cut off. So wouldn't he have been the one who was aggravated that started the whole scenario?
Well, I mean, we all would get aggravated in a moment if we've been cut off. You've been cut off, Nick's been cut off, I have, and we don't react violently. And if you believe what Hill said, that Cowan was cut off, but then it was Hill acting on his own, and Cowan didn't say anything like, darn, that car just cut me off, let's get him. There's no proof of that whatsoever.
No, but she does raise a good point, though, that, again, we're just always second guessing and inferring, but it's something no one's called and said that, but you would think that the driver of the vehicle gets a little more upset about being cut off than a passenger. I mean, that's something to think about.
Sure. I mean, it sounded, though, like Hill said it startled him, and, there's the theory. We don't know this happened, but the gun was on his lap. It could have, if they jerked it, the gun could have flown off his, lap onto the floor. He had to pick it up. He's annoyed. It could scare anyone. I know a couple times when I drive and we get cut off and I hit the brakes, it scares my wife more than it scares me.
It can if you're not expecting it. It really can. There's been some, we've all been there.
Yeah, so they can rattle your cage. You just hope it doesn't lead to violence in the aftermath. Let's go to Regina. Regina, good evening. Hi, Regina.
Hi.
Hey.
I have a question. With Mr. Cowan being found not guilty today, and prior to today, if he has already been on probation, would he have to go back and redo his probation? Pick up the charges for what he did prior to this.
Well, so it's important to point out when you're on probation that, and this is a common misconception, just being rearrested for a new charge, even though you're presumed innocent, is a violation of your probation. And a lot of times, you try to, as a defense attorney, there's a probation violation out there, which is a separate issue, and the court's got to determine, do I just make you serve your sentence? Do I put you back onto probation, or do I do a little jail time and then go back onto probation, like, kind of a hybrid sort of sentence here. So a lot of times you try to keep the probation violation, just kind of kick it down the road to try to get the new charge dismissed. And so if there was any probation violation, it's definitely in his favor today that this charge was dismissed. But again, if you go to Howard Gentry's website, the Davidson County Criminal Court Clerk, and you type in Mr. Cowan's full legal name, or just actually the first and last legal name, then he will come, and then you can look at his criminal history here in Davidson County. But he does have, I think they're still pending, some drug charges and gun charges from 2021, but they're in no way a huge felony charge like first-degree murder.
Oh, nothing. I think he has some pending federal cases, charges that were brought back in January of 2021.
Okay,
and there may be some others, but
right.
We'll see. I don't know if they've been resolved, how that's played out, but we'll be checking on that.
Typically on something like that would carry mandatory jail time, the Crooks with Guns law, but he might very well be looking at like a mandatory 2 or 3 years, maybe, on something like that.
Gotcha. So. All right, let's go next to, I believe it's Joyce. Good afternoon, Joyce.
Good afternoon, Nick.
Hey there.
Hey, could I ask the lawyer over there a question?
Sure.
He's always talking about gangs. Don't they try to get gang members off the street?
What do you mean?
Well, y'all talking about gang members. Don't y'all try to get them off the street?
Well, we just tried to get.
I'm from Dixon, and I've never seen any gang members around Dixon. Y'all was talking about them being members of gangs. Don't y'all try to get gangs off of the street?
Well, we try to get people that commit crimes off the street, is what it is, wherever it happens to be. So, law enforcement does.
And Nashville does have a bit of a gang problem. I mean, and that's no secret. And there's, particular gang units that we have within the police department that try to infiltrate that. But again, it's, somebody's got to commit a crime sometimes before you get on the radar of things.
That's how it goes, yeah. Let's go to Gwendolyn. Hello, Gwendolyn. Are you there, Gwen? I think I hit Gwendolyn. Okay, are you there, Gwendolyn? Go ahead, ma'am. Are you there?
Yes, can you hear me?
Yes, go ahead.
Okay, do you think Caitlyn Kaufman mom should go after the state now and sue the state for him being out after he did what he did?
Meaning they're disappointed in the verdict and there's no recourse. I mean, that's the way it played out. I mean,
yeah, there's no way to sue them.
There can be hindsight, and I don't think that you can make an argument here that there was poor. There are some choices that may have been made by the prosecution that if they have a chance to go back, maybe they would do over. But they had excellent prosecutors. I thought, we said all along, the defense team, I thought was very good. I just didn't think they had a ton to work with. And look, I was wrong. I mean, at least with regard to Cowan. But I mean, Jan Norman, Roger Moore are fine attorneys. I don't think anyone can sit here and say that there was misconduct or a poor job by the prosecution. The evidence just didn't match up for this jury.
No, and I mean, I don't think that there's a basis to bring a civil case at this time. I just don't see any way that they could do that.
What would a civil case? I don't know that I've seen that. You know, who sues when you lose like that?
I can sue the tree in the backyard if you pay me enough money. So you can sue anybody for anything. But clearly, when it comes to suing the government, they got sovereign immunity. They've got a real tight 1-year statute of limitations. It's got to be gross negligence.
Well, I don't know what the grounds are. There was no gross negligence here, period.
Okay, I mean, I guess not. I don't think so either.
What on earth? No. All right, let's go to Keaton. Keaton, go ahead, Keaton.
Hey, Nick, how are you?
Yeah, good. What's on your mind?
Well, you know, I've been watching this trial all throughout. I've been calling you and Nick, as I always say. Disappointed in the verdict, but just trying to keep it civil here. Thank y'all for what y'all have done covering this trial. One question. So the jury instructions took about, 20 minutes to read. What did the judge actually instruct on what the jury had to find for premeditation and then the lesser included offenses?
Well, we're not going to read the whole 20 minutes here.
No. But it's a good question because in the premeditation, something similar to this is what the judge would have said about premeditation. Premeditated act is done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exist in the mind of the accused for any definite period of time. The mental state of the accused at the time he or she allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. So,
okay, that's what was read, and that's how it played out. Look, we've gone through the calls, and just kind of want to wrap this up. As I said, March 3rd will be a sentencing hearing. At that sentencing hearing, do you expect that we will hear from Caitlyn Kaufman's family, and could we hear from family members of Devontae Hill?
You certainly could. You're certainly going to hear from the Kaufman family. They're going to give victim impact statements, but this is one of those situations where it's never going to be enough for that particular family. And of course, you're going to start off it's 15 to 20. You start at 20 and you go up or down based on enhancement factors. And so, you're going to hear victim impact statements from them. You're also probably going to hear from Mr. Hill's family members or some sort of family members that talk about his life and that the fact that he's a good kid or he made some bad decisions when he was younger, maybe that how tough his life may have been. We know that he's been in a foster home before, and I think someone reported that actually his mother had showed up to trial. So I would anticipate that we certainly would hear from family members, and then the judge will also have what's called a pre-sentence report, which is done by the State of Tennessee Board of Probation and Parole. They go out there, they meet with him, he gives his version of the events as to how it happened, they look at his background, they give him a couple tests to determine his likelihood of recidivism or to break the law again, and they puts together for the judge a little snapshot of the facts of the case, because not every case is tried. A lot of times they're pleas, and it's still required to have a pre-sentence report. But I will say what's fascinating, and it's a very sad thing, is that there's a lot of individuals that go to a sentencing hearing that have no one to testify for them. Right. They have no family, and all they have is this pre-sentence report. So I'm sure that Mr. Hill is going to have some family members. But again, Judge Dalton is going to be kind of limited between the sort of 20 to 25 year prison sentence, and it can go up based upon enhancement factors that would be found in the statute and come in and proof of that would come in at trial. And the truth of the matter is that the judge, if there was, let's say there was no mitigating factor and only one enhancement factor, or even two mitigating factors, the judge can place whatever weight they deem appropriate on those factors to increase the sentence. Mm-hmm. So only one enhancement factor. If Judge Dalton finds and places much weight on that factor, I mean, technically she could take it to 25 if she was to do that.
But again, it's the judge that does the sentencing, not the
Correct.
jury. The jury's job is done. They're home tonight. The sentencing hearing is March 3rd. We will be covering that for you, of course, when that happens. Just as we kind of wrap up our trial coverage here, it was 8 days, nearly 20 witnesses, 11 hours of deliberations before the verdict finally was returned on these two individuals. I want to keep in mind, as always, again, as we said all along, this case was about primarily one person, and that was Caitlyn Kaufman.
Caitlyn Kaufman behind us.
Okay, a young woman that, however you feel about this verdict, the fact remains she lost her life tragically and should never be forgotten. And remember, our hearts go out to her family and that loss. As far as the two individuals that were charged in this case, as you know, the verdict came down just a short time ago. James Cowan found not guilty of all charges, acquitted, will, if there's nothing else in line for him legally tonight, possibly return home tonight or in the very near future. And then Javante Hill found guilty, and he confessed, he admitted he shot and killed her, but not a premeditation. So second-degree murder, Nick, and you said just a moment ago that's between 15 and 25 years. He served 2 already. Let's say he gets 20, that's 18 years he will have to serve at 100%. And that's a lot of time. That's a lot of time for anyone to serve behind bars, but it sure beats the heck out of life in prison.
No, I mean, that's a victory. No matter what legal problems he has, the worst one of them was this charge.
There you go.
So, I mean, it's a downhill from here.
And as you said, this is something, it's very difficult to ever predict what a jury will do. You can have your preconceived notions going into it. You don't know everything they see and what they're hearing and going through back in that room. And that's the way it played out. This is the verdict, and you have to accept it. This is our justice system.
Well, it makes you wonder, too, if, and we'll probably never know the answer to this, but I wonder if, Mr. Munkabo and Mr. Chafin and them had offered to plead guilty to second-degree murder, right? You don't ever know.
You have no idea what goes into doing these gavel-to-gavel trials.
That's
and we've told people how much we wish we could do this on every trial, because Caitlyn Kaufman, tragic, horrible, and she deserves this attention. Every other murder victim or other serious crime deserves it. We wish we could do more, but a wonderful job by our staff back there, okay? Kristen and Josh and Rick Casey.
Yeah, Rick does a lot.
This doesn't happen without him. He's incredible. And the support staff from down there, our news director, Sandy Boonstra, of course, our viewers. A lot of opinions out there. We share this. We do commentary. You may agree, disagree as we go through it, but hopefully we always respect each other. So many of you have followed this, not just locally, Nick, but we have people all over the country and even overseas that were following this trial. If nothing else, when we do these, I hope it's instructive to you how our justice system works. I think every time we do one of these, I hope people learn, and you get a look at how it plays out. And again, this is something that's very hard, and someone lost their life here. And again, the verdict back this afternoon, James Cowan, not guilty. Javante Hill, guilty of second-degree murder. We'll never forget Caitlyn Kaufman. And of course, this trial coverage for us, without you, Nick.
Hey.
The guy's the best. I get teared up even talking about it. You are fantastic, and I really appreciate you being part of our coverage. I know our viewers really value it, and thank you for coming on and giving such great perspective about this.
And you've, when I've had to step away to do things, I'll still, try to listen so I can be caught up when I get here. And you've picked up a lot over the years, even with the other legal analysts before myself. You probably about 90% of what you said is correct from a legal standpoint. So, and you enjoy doing this, and Channel 5 is kind enough to dedicate you to this for this period of time, and you enjoy doing this, and so it's fun to be able to do this with you. And again, I want to echo what you said about Rick Casey and the job that he does. It's a lot running the Plus station here. It's a whole
network of how it goes on.
Because just like Judge Dalton has other things going on, Rick Casey and the Plus has other shows that they film here in the studio, and so it's a lot to put these productions on.
Well, thank you. I really do appreciate it. But we view this as a public service. It's an important one to get the information out, and we're glad we could bring it to you. We're going to thank you all again for following us. Follow me as well on Facebook, Nick Barris NC. Tennessee 5. And tune in tonight to our newscasts. Of course, 4 is already on the way, but 5, 6, and then 10 o'clock tonight, we expect we'll probably have reaction that happened outside the courtroom. We'll have that for you there. So once again, that's a wrap. I'm sorry, Nick, what did you say? Oh, yeah, I want to remind you, Morning Line, we'll talk about this. If you have more that you want to discuss and take calls, we'll do this tomorrow on a special edition of Morning Line.
So my only question is, do you have a story ready for tomorrow yet?
I do have one. I always have something in my back pocket.
You never quit, do you?
Always something. I try not to. Hey, Nick, thank you again. Again, for all of the staff here, thank you all for joining us. Nick, you're the best. You're my good friend, and you're terrific. And I'm Nick Barris. Thank you for joining us, and we'll see you again down the road at our next Gavel to Gavel. Have a good evening, everyone.